All right. Well, I think we're at that time where we'll get this thing started. So, welcome to the March Fireside Chat. This is our first of the year with an outside guest. So we've got Christine Cooper with Aequum joining us, and we're very happy to have her on board. I think this is a conversation that a lot of people have been interested in and talking about in the industry. I think there's some misunderstandings out there too about, what does fiduciary mean? What does a legal product do in an RBP environment? And all those things are going to get answered for you today. So with that, let's do some introductions. I'm Heath Potter, Chief Growth Officer for 6 Degrees Health. The 2023 season of Fireside Chat, and I'm now your host. I got upgraded, I guess, from just being the guy that read off questions as they came in. So now I'm a multitasker, but happy to be here doing the introductions. So Christine, I'm going to turn it over to you to say hi. I think is there a slide, Jessica, that has an agenda? Okay, see, I'm already failing at being the host. Okay. So that agenda, I'm sure, was important, but we're going to do all the things that it said we were going to do. So Christine, she's the co-managing member of Fuller Fitzgerald Law Firm, leads the firm's healthcare practice, and then has a big passion for technology. So Christine, you want to say hi to the group?
Hello, everyone, and thank you for letting me join you today.
So I've had the pleasure of spending some time with Christine at our symposium here last month, and she did a presentation for some of our client guests and members of our team, and did a phenomenal job. So I'm excited to have her here doing this for you guys today. And we're going back to the agenda. All right, we're going to go through reference-based pricing, legal advocacy, teamwork approach to legal advocacy, plan participant. Jessica, I don't want to read all this stuff. It's going to be a great presentation. So there we go. We got one for Scott too.
I don't think
Next
we
slide.
did.
Oh, yeah. Well, you don't need an introduction. So Scott Race, founder of 6 Degrees Health. He and I have been doing this for a long time, not just Fireside Chats, but working together going back to, I don't know, 2008, somewhere around there when we first met. So pleasure to have Scott on the call today. Scott, want to say hi to everybody?
Yeah. For those that haven't met, founder of 6 Degrees Health, and Heath, we go back before that even. I think it was more like 2005, but just quickly, we.
Oh, you know what? 2008 is when I got married, so it was another very important date. So 2005 is when I met you. That's right. Okay.
Right. And I just briefly wanted to say, we formed a relationship with Aequum back in 2001, and we've had a phenomenal experience with them, and really like what the partnership that we formed, and how we blended our process with theirs, and we're just getting exceptional results. And after seeing this work for a couple of years, I'm really sold that it is a far superior strategy to kind of the historical fiduciary approach to that some vendors take. And so really looking forward to this, and I'll chime in and add some color here and there. But Christine, you want to, or Heath, I guess I'm kind of taking over your role. Do you want to launch this thing?
Oh, you're doing just fine. A couple things though. For questions, there is a tab at the bottom of your screen. So if you got your Zoom browser open and you hover over your screen, that bottom bar pops up. There's those little chat bubbles that pop up that says Q&A. If you could use that to ask questions, and I encourage you to do so, we'll filter your questions in throughout this recording. By the way, it is recorded, so anybody that misses something, we'll post it on our website and you'll have access to it. But throughout the recording, you can ask questions. I'll filter them in, but if you use the Q&A piece, that definitely makes it easier on myself to find those. Sometimes people use that chat function and they get lost, especially if there's a lot of chatter going on. So use the Q&A piece for questions. But other than that, let's turn this thing over to Christine and we'll get started. So thanks, guys. Enjoy.
Well, thank you, and thank you for the introduction. So we called this legal advocacy protecting plan participants and plan savings because both those key players are so important in how we view what we do, and how with the key players in the space. So if you go to the next slide. So how reference-based pricing plans use legal advocacy, we really come into the picture post-payment. So after the bill is initially paid and processed. And I know there is additional work that's done prior to a bill being referred to Aequum. But what we provide is post-pay bill defense. So we're defending those really difficult balance bills. We negotiate the bills if and when we have authority and if and when the providers are willing to negotiate. We provide credit repair assistance when necessary, as well as actually handling the lawsuits with the litigation defense. If you go to the next slide.
Hey,
So
Christine,
yes.
Just one quick point here. Just wanted to add, like, how 6 Degrees works with Aequum is we still run our typical process in terms of most of our clients give us authority to a certain point to settle balance bills. And so we still, for our clients that elect to bring Aequum into the solution, we'll still run our process and try to settle out as many balance bills as we can within the authority granted by the plan. And so it's really that, as Christine alluded to, the problem providers, the more difficult balance bills, those are the ones that are going to Aequum. Just wanted to clarify that to make sure people didn't think that, if a balance bill comes in, we just automatically hand it over.
And this goes to our teamwork approach to this advocacy. While we step in and provide the legal advocacy, we know and work with 6 Degrees in advance on those bills with, sort of coming into the picture after 6 Degrees has done all of its steps or gone through all of its steps with its process. So it's a very seamless transition, though, between 6 Degrees and Aequum as we're being referred these bills. So our teamwork approach to legal advocacy includes all of the key stakeholders. You've got your third-party administrators, brokers, the plan participants, employers, the lawyers through Kohler Fitzgerald and Aequum, as well as our partners, 6 Degrees Health. So really how we work our product, or how the process flows, is claims are referred to us by 6 Degrees once they hit that wall and the providers no longer or become unfriendly or difficult. We work with the TPAs, we communicate with the TPAs so that they know what's going on with their claims and the claims that they're handling on behalf of the plans. We communicate with the brokers. The brokers, having broker buy-in is a key piece to having a successful reference-based pricing plan. That's what we've found. There are many brokers that are very hands-on with their plans and with their plan participants. And so we want to make sure that they're comfortable and they know what's going on in the process. The plan participants are actually Kohler Fitzgerald's clients. So that's who is forming the attorney-client relationship, or who we're forming the attorney-client relationship with. These bills tend to cause plan participants anxiety. We've learned that educating them, as simple as educating them on how to read their EOB, on up to educating them on the process, is really important. Many participants don't understand their insurance until, or their plan until they get involved in it, because it's a lot of information to take in. So until they have a balance bill, they may not understand how the process works. They need some assistance understanding their medical bill as well. And all of that helps to calm their anxiety and work through the process. So we've found that communicating with them and educating the plan participants is really important, along with representing them as their lawyers. So then we have the employers, also very important stakeholder in this, as they tend to be the plan sponsors of these plans, and they also need to know the status of these claims and what's going on. Then we have really the legal advocacy team, which would include the lawyers, our customer service representatives, and everyone who has their hands on these claims. So we need to be mindful at Aequum of everyone's pain points and try to seamlessly work between all of the parties to make sure that everyone's getting the information they need. These claims are being timely resolved with good results. We're being mindful of plan savings as well as noise from the plan participants. We all share a goal. All of these key stakeholders share the goal of reducing healthcare costs for both the employers and the employers while reducing the discomfort for those plan participants as they go through this. If we want to move to the next slide. So plan participant engagement is really, really important since we are representing them. The key here is that they understand the process, that we can provide routine and predictable communication, share the key information, educate the members on what's going on with their particular bill and answer any other questions that they may have along the way. We feel that it's very important to be available for any member questions incoming, but also we know that there are some that are very quiet. So we believe that you have to have frequent contact with the plan participants, and our process is to communicate with each one of them at least monthly. We ask, these plan participants, how frequently do you want communication, phone call or email, or their preferred way of communicating with us. Some pick every other week, some pick weekly, but most we're communicating with monthly. When a claim is initially referred, before they ever get a letter from us or any other piece of information, we make a call to them. We introduce ourselves. They often know our name because they've been educated prior, but haven't had necessarily an experience or a chance to work with us. So we like to introduce ourselves, go through, run them through the process, run them through what to expect. We have a database where we keep information related to all the providers that we've worked with. So long as it's a provider we've worked with in the past, we can usually provide them very detailed information as to what's going to happen with their claim. And that type of uncertainty or bringing that into the realm of certainty usually eases the anxiety and quiets the noise from that particular plan participant. They have access to an attorney. There's an attorney assigned to every plan participant that is referred to us, and they know they can schedule an appointment with that attorney should they need to or should they want to. But we also have customer service representatives that are reaching out to them with updates on their case and other information that's pertinent to them and to their claim. So we like to set expectations. I have honesty on here because I think it's really important to be honest with these plan participants about what's going to happen to their bill, the likelihood that it's going to be sent to collections, which collection agency may be used, at what interval might that happen. All that information, just being honest with them about the process and what the process looks like generates a tremendous amount of buy-in, and they can feel some ownership over what's going on with their particular claim, as well as they understand, hey, I'm helping lower my healthcare costs, both for myself and for my employer, which is generally a good thing. So the key for us at Aequum is really this relationship building. We're building the relationships amongst all the key stakeholders, as well as, and in particular, with the plan participants. If you want to, very good. So provider side engagement, a very different type of relationship than what I talk about with the plan participant. So providers being the hospitals or the physicians, primarily it's the billing departments. So we're cognizant of who we're talking to when we call up that provider. We have found that simple communication and message consistency and utilizing plain language is the key to getting results with those providers. When we're getting a billing department individual on the phone, spouting legal cases or statutes at them doesn't resonate. So, we really focus on trying to make them understand why the amount that's been paid is the reasonable amount and all that they should receive. And that carries into our negotiations that we do for the on behalf of the plan participants. We are very respectful. We don't want to be overly aggressive with them. I mean, we're building a relationship with these billing folks as well. Same runs to the collection agencies. While there's some turnover at those agencies, we tend to get the same people on the phone time and time again. And what we've found is just by being, respectful, I call it friendly aggressive, because they know that we're taking a hardline stance and we have certain authority and we're not going to go above that. But being respectful gets us some traction. So the other sort of key to building this relationship is making sure we're getting to the right person, getting to that decision maker so we can have that discussion. Sometimes that's an individual in the billing department. Sometimes it goes up to general counsel or assistant general counsel. It really depends on the bill, the size of the bill. It could depend on how they're structured, how that provider is structured. So we try to build relationships within that provider side as well. Next slide. So provider collection tactics, they use quite a few that we are, very aware of and have worked through the processes of these. The first one is collections. So bills are often sent to collections during this process. We know at this point, Aequum has worked with nearly every collection agency on the medical debt side. I say that because I have not seen a new medical debt collecting agency come through in well over a year at this point. We have built relationships with each one of them. They know who we are. Like I said, we're getting through to the same people time and again. So we have a pretty good contact and quick contact with these agencies. We've tracked about 400 agencies over the years we've been doing this. That allows us to provide a lot of predictability on what's going to happen with these particular bills. Another pattern that we've discovered in handling these bills for the length of time that we have is certain agencies will give steep discounts at certain times of the year as they're closing their books. So we've utilized that to our advantage, but these are a lot of the trends that we can pick up on as we're working more and more with these particular providers and agencies. Other collection tactics we see are reporting to the credit bureaus, reporting certain medical debt to the credit bureaus. Now, there are new rules that should be starting soon, maybe as early as March 30th of this year, where medical collection trade lines less than $500 are no longer going to be reported to the major credit bureaus. And that's about 2/3 of the medical collections that are currently on people's credit reports. So that's a huge change. What we see with credit reporting are those smaller bills. I think it's the bills that they think they can scare people into paying. So we have a credit repair process that I'll talk about a little bit later, but that credit repair process is a process we go through to help remove that derogatory mark from the credit report. There are some state rules that allow public hospitals to utilize tax liens where they may garnish or attempt to garnish the state income tax return refunds. We see that happen in a couple of states, primarily right now, South Carolina and Utah are using that as a tactic for certain hospital providers. The lawyers at our firm will talk to members that receive a letter. There's a process that needs to be adhered to, an administrative process. So we work through that process with them. And we also suggest some other changes that can help protect them. And then litigation. Now, litigation is relatively rare. We're seeing about 1.6% of the claims that are referred to us end up in litigation, so end up in a lawsuit. It can happen. It's really tied to particular providers that we see. And in fact, the bulk of our litigation over time has been with one particular provider down in Texas. So it's while it's very important to provide the litigation defense, it's not as frequently occurring, I think, as people think or are afraid that it is. Next slide. There's a couple more that I didn't put on the slide with respect to collection efforts that I do just sort of want to mention. One is medical debt financing agreements. Having an attorney review whatever is being presented to the plan participants is really important, because a trend that we're starting to see is hospitals providing information to medical debt financing, which would create a contract for the amount owed. So if a plan participant signs a payment plan through one of these medical debt financers, they're on the hook for that. The plan participant is on the hook for that, because now they've created a contract with a separate entity, not the hospital, who then funds the hospital bill. So we're seeing some of that play out. It's they've been brought to us. We haven't had anybody sign one, but we're becoming aware that this is a new technique to get paid, not limited to reference-based pricing, but just a new technique that we're seeing hospitals try to utilize. And it's primarily on the larger bills. So the resolution of the bills can happen in a couple of different ways. One, we're seeing increased affirmative write-offs, meaning we'll challenge the bill and we will get a $0 statement from the hospital showing that an adjustment has been made for the full value of the balance bill. There are quiet write-offs, or what I term quiet write-offs, where we may not get a affirmative bill showing a $0 balance, but a period of time, and we use the 6-month mark, because after tracking these, we've learned that if a bill goes beyond 6 months with no further communication to either us or to the plan participant, then that bill has been written off with rare exception. And we do reopen claims when that happens, although again, it rarely occurs. So providers and collection agencies are writing these bills off without ever sending a statement that shows a $0 balance. We attempt to settle the claims within reasonable authority so that we're preserving the plan savings. We utilize the state and federal consumer protection laws to challenge the bills. So if a collection agency steps out of line, for example, we will use the Fair Debt Collection Practices Act to seek termination of collection of that bill with quite a bit of success, because there are penalties that can be brought against the collection agencies for violating that act. So we're always on the lookout for that type of mistake, I guess I would say, by the collection agency. Now we're evaluating claims to see if they should have been part of the No Surprises Act, or vice versa, if we're seeing IDR or open negotiation notices on particular claims, to see if they should be part of the No Surprises Act or if they are ineligible. So this is sort of a new layer of legislation that we're constantly evaluating. And then there are the financial aid applications, and those are the under 501R of the IRS code. The hospitals, the charitable hospitals, have to provide a financial application or make a determination that there is no they don't reasonably qualify, the plan participant doesn't reasonably qualify for a deduction of or reduction of their fees. So that's another, we will evaluate to see if it's appropriate to utilize that financial aid application to reduce or eliminate the plan participant's bill. We don't often recommend going through that process because many of our plan participants don't meet the individual hospital requirements. And beyond that, those applications contain requests for a tremendous amount of information that may be used in collection tactics. So for example, account numbers, you have all your date of birth, social security numbers, assets, listing assets. So it really sort of gives the provider a roadmap, a collection roadmap, if you will. So we very carefully use those only in instances where we vetted the member and know that they would qualify, and for providers that have favorable processes or policies, financial aid policies. And I say that because each provider can have its own policy. And I'll give an example. We had one that we did utilize the process for, but this particular provider only allowed you to go through the process one time. And so, it was a situation where there were quite a few bills that could be processed under that one application, and it was worth doing. But from our perspective, we have to look at every one of those policies to determine if it's valuable for us to utilize it. So those are the key ways we are resolving claims, always with the focus of plan savings and reducing noise for the members at the same time. So there's sort of a balance in there. Next slide. So our results. Right now, we have saved 95.5% off the disputed charges. And that includes some settlements that we have received. Many of our plans do not want to contribute additional funds to settlement, so that's reflected in this number as well. But these savings are really key to our success and to the success of the reference-based pricing plans that we work with. We're often asked, how fast is this going to get resolved? Our average right now is 297 days from referral to Aequum to resolution, and that's about 10 months. The reason for that amount of time, we have to obtain certain documentation from the plan participants, a HIPAA authorization form, for example, a signed engagement letter. The more tech-savvy plan participants that we work with, we get that information back very quickly using electronic signatures. But there are many that want paper copies of everything. So we're still using snail mail in quite a few circumstances. So that builds some time in. Then you've got the negotiation, the obtaining information from the provider, the actual negotiation time as well. Where we have more authority, that number comes down. Where we have less or no authority to settle claims, that number goes up. It's pretty, it's really tied to, can we negotiate to a resolution, or do we need to fight this bill till the bitter end? I said I would come back and talk about the derogatory marks on credit, because it is probably the biggest pain point we see with our plan participants. About 0.9% of the plan participants that have been referred to Aequum have notified us of a derogatory credit report mark. And of those, we have been able to remove about 40% going through a credit repair process. What that process looks like is really reaching out to the credit bureaus as well as the collection agency that placed the mark, and disputing the mark with all of those entities. We cannot monitor people's credit. It's not something we're permitted to do. So we do have to rely on those people coming to us. Other things that we have had happen, oftentimes we ask every plan participant that we represent to monitor their credit report. We tell them when we know what collection agencies do report to the credit bureaus. So we let them know all of that ahead of time. That being said, some people do, some people don't monitor their credit. Sometimes they'll go to refinance their house or buy a car, and a mark will be on there. And we have a very specific process for that. But we work with the lenders. We have not had a member be turned away for a loan due to a medical bill being on their credit report. So we're very mindful of those processes and the needs of our plan participants. And so we work closely with the lenders when that arises. So those are some of our metrics and some of how we do it. And I think we are through the outline.
Yeah, Christine, I was going to say there's a couple of questions that I hear pretty often, out from clients, and probably the most common is, around fiduciary.
Sure.
Who is a fiduciary and who is responsible for any additional payments in an RVP environment?
So the fiduciary question is really interesting because I think in our industry, it's used a lot in a way that isn't necessarily the legal definition of a fiduciary. So a true fiduciary is the entity that has control over the plan and the plan assets and what's done with the money essentially in the plan. More often than not, the plan document would provide that the plan sponsor or plan administrator is the fiduciary under the plan because they're the ones making the decisions on how to direct the funds. We do not take on fiduciary responsibility, and there's some key reasons for that. One, we don't have access to the plan funds. We don't intend to have access to the plan funds. We don't want to direct. I think that becoming a fiduciary outside of who's named in the plan document really incentivizes chipping away at the savings that the plans are seeing, and also creates the opportunity for additional legal liability. As far as, you really have to carve out what those duties are going to be and be very careful with it. So, if you're incentivizing settlement, then the cost to the plan is going to go up. That's got to get passed on somewhere. Presumably that also gets passed on to the plan participants. So, from that perspective, I think leaving the fiduciary duties where they typically lie as drafted or as written in the plan document is really important. It also, taking on a fiduciary responsibility or role doesn't change who's legally liable for a balance bill. I mean, that is going to run, assuming the plan document is drafted as such, that's going to run to the plan participant. From a purely lawyer standpoint, that plan participant is on the hook for that balance bill if it went through the court system, and not the plan, so long as the plan paid in accordance with, under its obligations. So the fiduciary thing does come up a lot, but in my opinion, it makes sense to leave that fiduciary responsibility where it originally was, and that's with the plan sponsor.
Yeah, I wanted to comment on that. I think this is a huge point, because this fiduciary topic has been an issue for years, and there are vendors that use it as a selling point. And my position is it's actually a strategic disadvantage to put yourself out there as communicating with the provider as the fiduciary of the plan, because that's what the provider wants. The provider knows the deep pocket here is the plan. They want to continue a conversation where they know they can get money out of that plan. Contrast that to what Christine is talking about, which is, hey, 6 degrees in the plan, they tried to settle this case, were unable to. Now the attorneys are representing the patient here. And again, getting back to kind of this underlying legal obligation that exists, it's really a contract claim between the provider and the patient. Meaning if you dig into the terms that nobody reads when you go see when you go to the hospital, where they say, hey, you're going to pay me whatever your plan doesn't reimburse, that's ultimately where that provider's hanging their hat. And so it changes the dynamics of the conversation when the provider is thinking, now I'm trying to get this resolved with just the plan member. Okay, they don't have the deep pockets that the plan has. And that's why I think part of the reason Aequum is seeing such good results from a savings perspective. And I think the other point here that's interesting is the time to resolution is quite long. Okay, and some people may see that, think that's not a good thing, but there's this kind of this inverse relationship between time and the level of settlement that you're going to achieve with a provider. And I tell people, who get really overly fixated with needing to settle balance bills in a very short period of time with a provider, it's like, we can make that happen, but you're going to see your worst discounts if you're going to follow that strategy, right? Because just negotiating 101, they're going to start from a point where, that's most advantageous to them, and get a settlement that they really are that they're trying to achieve. As that AR ages on their balance sheet, okay, it becomes a lot of CFOs, their compensation is tied to AR aging, right? And so as that ages, they are going to become more interested in trying to get this off their books. And then you combine that with this dynamic that we've created with Aequum and Kohler Fitzgerald representing that patient. I think that all ties into why they're achieving the success there. And then the other part of this too is, with our model, we still have clients that don't use Aequum, and there's nothing to say that they can't play that waiting game as well. But what we've found is that the anxiety that the patient has to endure through that process of being harassed by the provider, threatened collections and credit harm and all that, that's a bit too much for a lot of plans. And so having, the law firm and Aequum involved in this to provide some comfort to that patient, that's invaluable. And it also, they've been very successful at kind of stopping that harassment through this process. And so it makes the journey of that, just, going through that time to settlement much easier than, contrasting, just having 6 degrees kind of wait out this process.
Well, and sort of to build on what you said there, the providers and the collection agencies know that we represent that individual member. We've made that clear from, the start of us doing this work. And it's interesting because, they're not getting a batched letter from us with 10 different members on it or member names. They're getting an individual letter, even if it's a large provider where we're handling, a large amount of claims on behalf of multiple members. They get a letter for every member that we have. We individually negotiate every claim, and they know that going into it, which gets us, it gets us, and it gains an advantage. With respect to litigation, I mean, representing that member, you've got, big provider walking into court suing, a factory worker, for example, making $20 an hour. No jury's gonna go in favor of that big provider, or I shouldn't guarantee that. As a lawyer, I'm not allowed to do that, but it's unlikely that it would come out in favor of the provider. So there is a tremendous amount of opportunity when you're talking about representing that plan participant over representing the plan. And that is something that we have spent a lot of time distinguishing and explaining to those providers, so they know, look, there's no deep pocket here. This is the plan participant. This is their liability. And they're not, they're not going to pay you because it's unreasonable. And even if they could pay you, or even if you were successful, you're not likely to collect because they're going to be uncollectible.
Hey, Christine, I wanted to make one other point that I think contributes to the lack of desire of providers to pursue litigation, and it has to do with just the price disparity that you see. And for our clients that use Medivy, they know this. You can see a hospital that marks their bills up, say 3 times what Medicare reimburses. And then down the road, you'll see a hospital that marks 25 times Medicare, right? And if you talk to a hospital CFO, that what they would say off the record would be like, the bill charge doesn't matter. It's just this fiction that is a relic of our network structure, right? I mean, they'll say what really matters is what health plans are paying, meaning, if they're offering a 90% discount to a network, they're not collecting 25 times Medicare, right? And that's the reality of the traditional system right now, which is the pricing doesn't make any sense, okay? But when you take that pricing out of the traditional context, now they have to say, well, yeah, I am owed 25 times Medicare, which is ridiculous, right? I mean, it is just absolutely ridiculous, and they know it. So, walking into court to try to justify that against, like I said, that $20 an hour employee, that's not a case that I would want to take to court.
Okay, we've got some questions that are coming in here. Some of these, I think I can probably answer. The others, I'm going to kick over to Scott and Christine. So one of them asked, when things are negotiated or outcome or choices are either accepted or declined, where's this solution included in that? And so the Aequum product is built into our MediShield solution, which is something that we launched a couple of years ago. And for clients of mine that are on this call, I was going to wait to make sure that it was going to perform above expectations, and it really has. And so it's not something that I pushed out there 2 years ago or even a year and a half ago, but we're seeing the results now, and it's been very, very good. So many of you probably do not have this solution as a part of your current RVP product. And so this is something that you can add. And so Joel, that has not been included in what you guys are doing. Our core product is designed to avoid the need for legal, and it's done a really good job for that over the course of 6 degrees. But what we're finding are there are some problematic providers that are starting to play a little bit tougher. We also find that we have clients that are looking for an easy button where the legal component is just built into it. So we provide it as an option. It's something you can add to your current plan or something that you can add to new plans going forth. And it will work just as Christine has explained here. So the other question, and Scott and Christine, I'm going to kick this to you, is the question is, we're seeing providers like a multi-care, which is up in the Tacoma area, send the bill to a payment plan service that really is a balance bill or an entire bill, and the payment plan is established without members' permission, i.e. it's functioning as a collections. How do you address that?
So from my perspective, that is not a valid contract. They can do that all day long if they want to, but that member is not under an obligation to pay it. And if we do see that happen, sometimes you'll get a collection letter and they'll say, we'll take $200 a month for X amount of months. We tell or we advise our plan participants not to accept that. Do not sign anything. Do not start to pay on it. Let us go through our process and walk you through the process. If a collection agency or a medical biller is automatically doing that, I think it's not a valid contract and it should be ignored.
Thank you. Okay, we have two questions I think that are kind of hitting on a similar front here. If a provider goes to litigation, can they also stop servicing people on your plan?
I can add a couple of points to that. I mean, litigation doesn't change that issue. A provider could, in theory, throw up an access issue, to any non-contracted plan, right? If a patient shows up and that provider isn't contracted with that plan, say through a network, they could throw up some access issues. And now that's for elective procedures. They obviously can't do that for emergency visits. And again, if they have to service emergency visits under federal law. And also, the No Surprises Act also covers those claims in terms of if, prevents the provider from balance billing the patient. They have to go through that IDR dispute resolution process on those claims. So it doesn't necessarily create access issues. And even facilities that we do tend to see more access issues from, they're not consistent, meaning, there's a large clinic in the US I won't name, but they're known to create some access issues. But when we look across our entire book, the majority of the cases still get access to them. So it's how they figure out when they're going to create an access problem for a particular patient. I've never been able to figure that out, but it's not consistent. And Christine, I don't know if you have any other thoughts to add on that point.
Yeah, I'll just add, as I think across our litigation, there's not one provider that comes to mind that will not accept patients, even though they litigate bills. Many of the, or actually, I really can't think of a single one that throws up a block. And I know the provider that Scott is alluding to, they are actually one of the least aggressive on the collection end. And very, very predictable in how that bill will end, assuming the plan participant can get their foot through the door. So much of this is provider by provider and not necessarily tied to their, any particular collection tactic, I guess I would say. But yeah, with respect to litigation, there, in my experience, there's no connection to preventing a plan participant from actually accessing the facility.
And if that were potentially to occur, just like Scott had mentioned, the standard 6 degrees process is to, to reach out and help facilitate access to, the care that the member is seeking. So, okay, several questions have come up about cost and getting access to MediShield and Aequum. I try not to get too deep into product specifics on these, and there's a couple of reasons for that. One, I don't want to make these things an advertisement. Two, they're open for the internet to watch. So it is something that you can add to a standard 6 degrees RVP solution. You can do it both as a PEPM or a percent model, and feel free to reach out to me directly or your territory representative of choice. So we can walk you through all that and get you all the information you need to make an educated decision if this solution is right for you. And it does work really nicely on certain plans, especially if they're running into tough resolution on balance bill situations. So something for consideration. Okay, I think this one is probably a good one for Christine. Of the 300 average days resolution time, has that had much impact on stop loss reimbursement due to contract basis, or is it negligible because of the 95% savings? And Scott, you may need to tap in on that too.
Yes. So we don't have the contract, obviously, with the stop loss carrier, but what I can tell you is stop loss carriers love what we do because they're not hitting aggregates and we're saving them on the catastrophic claims. So the stop loss carriers that our partners work with tend to be very open to working with them on the reimbursements because there just aren't that many reimbursements. So we accept claims, very small claims on up to very large claims. And by very small, I mean, $100 or $200 or we'll take any size claim. And because of that, those little claims really add up and protect, in a way, the stop loss carriers as well. So they benefit from the plan savings, obviously.
Yeah, the only thing I would add on that is, keep in mind, again, going back to what we were talking about, the underlying claim is a contract claim between the provider and the patient. That's a state law issue. And so each state law has their own statute of limitations in terms of the time that a provider can bring litigation against a particular patient. And so it varies, but that statute of limitations could be 7 years, right? I mean, it could far exceed the thresholds of a stop loss contract. So you're always going to run that risk, and it's highly unlikely, but it's possible. And if Aequum was handling a particular case where the terms of that stop loss treaty had expired, and the plan would simply not be able to get reimbursement for helping to contribute to the settlement, that may prevent the plan from participating in that settlement, right? And that's probably going to drive a deeper discount for Aequum, knowing that the patient just doesn't have the resources to to settle that type of a claim. So it's a great question. It's a great issue. I think these are the things that can be made an issue when we're talking with providers, because also when 6 degrees is involved, I think as we get to the end of a negotiation where we're trying to get this resolved within authority, I don't think it's a bad strategy just to say to the provider, listen, if we can't get this settled, then it's going, to Aequum and Kohler Fitzgerald, and now you're going to have to deal with, the attorneys representing the patient, and so try to create an incentive for that provider to be reasonable and to settle. Stop loss may be another reason for them to do that. For example, if get in a situation where it's like, we got to get this claim settled and paid by this date, or the plan's not going to be able to get stop loss reimbursement, that's going to change their appetite to settle.
All right. Christine, Texas, everyone's favorite state. What are you finding with the providers down there?
So I've heard a lot of negative things about Texas, but we have one particular provider that we fight with all the time. That is UMC, or Lubbock County. The rest of them, I would, put with any other run-of-the-mill provider. So we've handled quite a few claims across that state. And the only really truly difficult provider is UMC. The rest of them are like any other provider we deal with.
Any other states of interest where you guys see firmer pushback? Or
so it's not really state by state so much as provider by provider. There are difficult providers in certain states. I'll call out a couple. I will call out Indiana Health. I will call out Spartanburg. They tend to be just more difficult. But it's not state by state. And one thing I think that's important to remember is much of state law does not apply to these plans, these self-funded plans, since ERISA applies and preempts most of the state law. So where an insurance company may have difficulty in a particular state, a self-funded plan doesn't face the same issues.
Good to know. Is there any way for a plan to make sure that even though a jury finds in favor of a provider, that the member has no liability, i.e., can the plan reimburse that member after the fact?
If the plan document is drafted in such a way, or the plan wants to amend or make some kind of rule regarding that within the bounds of not discriminating and things of that nature, that there's no issue with a plan doing that.
Okay. If a member or a patient has this in place, does it follow for the life of the balance bill even after the employee is terminated or resigns?
We have always handled balance bills through resolution. We have ethical obligations as lawyers to not abandon a client absent certain or for certain reasons we can. But in my experience, since we've been doing this, we have continued to represent terminated employees until their bill is resolved.
Okay. Wisconsin, another state getting called out. Any Wisconsin stories?
We have had balance bills in all 50 states. I will be candid, Wisconsin doesn't stand out to me. So I am certain we have had balance bills there. I would have to do a little digging to know what they looked like and how they resolved, but they don't stand out.
So when they don't stand out, that's a positive. I'm taking.
To me, that's a positive, right? Because
Yeah,
if they stand out or a provider stands out, then they're a real pain. If they don't, then it probably followed a pretty standard course.
All right. Okay, we're down to a couple minutes. I don't see any additional questions coming in from the audience, and good participation from everybody. Christine, any words you want to leave the audience with, and then I'll close things up here.
Some parting thoughts. I would just say, I know we're a law firm, but we take a much more tactful approach than I think our stereotype gets. And I would just say, I hope I get an opportunity to work with all of you and to share our information. And thank you guys for participating.
Yeah,
that's a tough one. Like we want them to participate with the program, but we really don't want them to have a balanced bill to have to work directly with you. I mean, it's a catch-22.
Well, that's true. That's true. Although, you know, it is what it is, and we try to make it more pleasant for everybody.
Yeah, I just want to echo that too, because 6 Degrees, our approach to reference-based pricing really was filling a need where trying to settle these disputes without being unnecessarily adversarial, like some vendors do, and so we haven't changed that philosophy, and you know, partnering with Aequum and Cole or Fitzgerald, you know, we do like their approach, and we feel that it's appropriate for, like I said, those really problem cases where we can't get resolution. So we're very happy with the partnership, and definitely appreciate Christine's time, and let us know if you have any more questions. I know there were some pricing questions that we can follow up with, you know, on a ad hoc basis with those folks, and get you that information.
All right. So our April Fireside Chat is going to be on April 19th, and we're going to have Ryan Work of SIA. So Ryan has been a regular guest for us. I think he's done this probably about 3 years running now, and always bringing new information. He's on the inside of all things up on the hill there, and does a phenomenal job. So hopefully you guys can make it. If not, we always record these, and you can find those recordings on our website under the cost containment webinar. So including this one, it will be there at some point later today, I would assume, when Jessica gets that posted. Otherwise, we'll see you on the 19th with Ryan Work. So take care, everybody. Appreciate your time today.
Thank you. Bye-bye.
Everyone.